To the courts now. The Constitutional Court is today hearing Jacob Zuma's application to have his jail sentence overturned. The former president is currently serving a 15-month prison term in the Escort Correctional Center. Let me take you to eNCA's Masego Rahlaga, who's been following court proceedings today. And Masego, it started out with Advocate Dalimpofu before I think I saw 9 justices being part of that virtual platform and hearing of the matter for the application for the rescission of the order and judgment. The mountain he must climb is to convince the court that it made an error in issuing that judgment and order in former President Jacob Zuma's absence. How did he go about trying to summit that mountain?
Well, Advocate Dalimpofu, as you rightly say, representing the former President Jacob Zuma, started off his part of the argument by saying that, you know, it's about making sure that the guardians are also guarded. In this sense, he's talking about the Constitutional Court justices. He's referring to the fact that he believes that they erred, even though they are judges who are at the highest court in the land, or the apex court, as we have been calling it throughout this period. So he says that they were not fair, in a sense that they went against Section 35 of the Constitution. He says that in that section, they basically did not give the former president the right to a fair trial. He says they did not give him the right to remain silent and the right to choose to not, continue with his testimony at the State Capture Commission of Inquiry. Remember, in this application to Recision, not only are they saying that the 15-month jail term was not fair, they are also saying that the contempt of court judgment or the contempt of court finding is also not fair. So they're saying that they want the Constitutional Court, as the court that was, the first reference, to be the one that actually rescinds the decision that it's made. But I also wanted to talk about Justice Zugisa Chikri, who then asked, obviously, Advocate Dalimpofu about this argument that the former president chose not to actually respond in this case and not to participate in it. He chose and elected that he wouldn't participate in this case, knowing that there's been an application by the Zondo Commission of Inquiry to find him in contempt of court. Here is Justice Chikri asking Advocate Dalimpofu about this specific argument pertaining to the former president deciding that he doesn't even want to hand in his heads of argument.
Is the remedy of rescission available to a litigant who deliberately decides not to oppose an application?
Yes.
And I'm asking this question because in Freedom Stationery, the Supreme Court of Appeal said that when you take a considered view not to participate in proceedings, you are reconciling yourself with whatever decision a court will make.
Yeah, I mean, the questions kept raining in on Advocate Dalimpofu from the various justices of the Constitutional Court. What was his response to this question that was asked by Justice Chikri?
Well, according to Advocate Dalimpofu, a crime is a crime. Remember, the Constitutional Court had to remind him quite a couple of times that this was not a criminal contempt of court case. It was, in fact, a civil contempt of court case. And his argument was that he doesn't agree with that. He says that a crime is a crime, whether a person is in court for contempt, whether a person is in court, for instance, maybe one person is on trial for robbing a bank but not killing anybody, and the other person is in court for actually committing a murder, at the end of the day, both those actions are a crime, and both those actions require that the accused person is given the chance to a fair trial. So he's still arguing that the former president was not given the opportunity to have a fair trial. He also said to Recision that he still has the right to ask for remedy, whether or not it's at the beginning point of a hearing or after the judgment has been made. It doesn't matter at what point that accused person decides to apply for remedy. He has the right to apply for remedy in this instance. He hasn't, for instance, to Recision, mentioned anything in pertaining to their argument in those papers that they filed for this hearing in the beginning about the former president being 79 years old and the 15-month jail term being something that is a death sentence, as they say in their papers. He hasn't gone to that argument yet. What they've been arguing about so far is Section 35 of the Constitution, which gives him the right to remain silent and the right to a fair trial, and of course that argument that he decided himself not to even participate in trying to get a fair trial by not handing in his heads of argument. But here is Advocate Dalimpofu himself explaining to Justice Chikri exactly what he thought was going on in this case. He says it's not as simple, or rather it's not as complex as people think. It's a pretty simple case. A crime is a crime.
Surely, particularly when you are exercising constitutional rights, the point at which you perceive your constitutional rights to have been abrogated, whenever that point might arise, whether it arises at point 1 or point 25, doesn't matter. But at that point, when you perceive that your rights have been infringed, you have a right to seek a remedy.
Rigorous, I suppose, is the word, Masego, in terms of the interaction between Advocate Dalimpofu and the various justices. I caught a bit of his interaction with Justice Majid. That was quite rigorous about some of the comparisons, and Dalimpofu saying that people are seeking to make the differentiation between the case of P.W. Botha and former President Zuma's case. He says actually that's a false difference that people are trying to draw there. It's been quite interesting.
It's been a very interesting time, and I mean, you can imagine when it's Dalimpofu, you could tell from the time he was still arguing in the High Court sitting in Pietermaritzburg last week with that application to stay, that application by the former president to ask the High Court to have the police not secure his arrest. You could tell from then that today was going to be quite interesting. South Africans knew that today was going to be quite an important day, but definitely Recision making that indication of that P.W. Botha case, saying that this is not actually as similar as people might think, but we're still far from actually getting to any point. And I mean, I think South Africans know by now that Advocate Dalimpofu does not, let his time go to waste, or maybe he always tries to get to a point and takes quite long. He's quite long-winded. So he's been speaking since around 9 o'clock this morning. The advocate, Ngugay Toby, who is for the State Capture Commission of Inquiry, hasn't gotten the chance to respond as yet. But just so South Africans know, we are not really expecting judgment to be handed down today. As you know, what would ordinarily happen is that the hearing would take place throughout the course of the day. It'll probably only end at around 4:15 or even later than that. Then it's likely that the justices, actually definitely the justices, will stand down and reserve judgment for a later date. And then we'll know whether or not they are going to overturn the decision to send the former president to jail for 15 months.
All right, Masego, thank you for that. And the issue gets even more complicated because you now have people who've applied to become friends of the court, and you have about 7 respondents, if I'm not mistaken. So it's going to be a long day for eNCA's Masego Rahlaga and the justices of the Constitutional Court. This is All Angles on eNCA. Coming up.